If you're dealing with a custody battle in the state of Nevada, it's scary because you know what's best for your kids and you may not agree. The way that the courts handle custody here is they determine what they believe is in the best interest of your child. There is statutory law, basically a statute that's published by the legislature, that says that there's certain factors the court has to consider. I'm not going to go into all of those right now because it's a lot. The courts are going to consider your ability to co-parent. They're going to consider the relationship of the child with each parent, and they're going to look at how you guys can meet your child's needs the best. They will also consider domestic violence and other kidnapping type actions by either parent. So make sure that you continue to foster that relationship with the other parent in any manner that keeps your child safe and secure. A parent-child relationship is so important. Making sure that you have the ability to have that lifelong relationship that every parent strives for is a big deal. If the other parent is trying to turn your child away from you or make you just have some disfavor in your child's eyes so that they are the quote-unquote better parent, that's unacceptable. The courts can issue a behavior order. A behavior order says, hey, don't talk bad about the other parent in front of the kids. Hey, don't let other people do it either. Hey, you need to knock that off because it's unacceptable. And the court favors equal relationships with both parents or favors the parent that does not engage in alienating behaviors. We really don't want children to be used as pawn. I actually have in our fee agreement that if you're going to use your kids as pawn, we're going to withdraw from representation because kids aren't pawn. Make sure that the courts are following what's best for your children. So raising a child comes with challenges and unique circumstances and unexpected happenings. We've all been there where, my 9-year-old will occasionally say, hey, Mom, I want to go do this. And it might be a 2 or 3 day event. And if you're co-parenting, you need to be able to adjust your schedules to take care of your child. There's a couple ways that can be handled. First, you can reach out to the co-parent and try and resolve it together without anybody else being involved. Work out transportation. Work out where the child is staying. And if you guys can agree, great. If not, and it's something that needs a court intervention, those temporary schedule changes are hard to address in court because it takes a little while to get in front of a judge. So a lot of times you're going to have to deal with that parent. If you cannot reach an agreement that works for both of you easily, it might be hard. The truth is, you may have to adjust your schedule. They may have to adjust their schedule. But what happens when you're co-parenting is that the order ultimately controls. So whatever the court has previously ordered, that is what you have to follow. That does not mean that your child can't participate. It means that the child's schedule might not change with the parents. Maybe the parent's schedule changes. Another time that we see this is when the child wants to do something that may be on mom's and dad's days, and dad doesn't approve or mom doesn't approve using their time for that event. The courts are always going to go back to the best interest of the child, and while we may not be able to fix this situation today or tomorrow, we can use this later in court when we're talking to the judge and explaining how do you guys co-parent and how do you guys put the needs of your child first. When they're looking at that custody for best interest of the child, that would be something that the court would consider. In Nevada, we have 2 types of custody. We have legal custody and physical custody. Joint legal custody means you each share in making decisions about your child's education, medical issues, and their religious upbringing. Joint physical custody means that neither parent has more than 60% of the time or less than 40% of the time. A lot of times people think joint physical custody is 50-50. It can be 60-40. It does not have to be exactly 50-50. That being said, primary custody occurs when one parent has more than 60% of the time. So for example, a 5-2 schedule means that the parent with 5 days has primary custody and the parent with 2 days has visitation. A joint custody schedule can look so many different ways. It's what works for you. I always encourage people to talk to an attorney about a custody schedule. And the reason is because when we think about doing a split of the week, for example, one parent gets Sunday night to Thursday morning and the other parent gets Thursday morning to Sunday night. That leaves one parent with no weekend time. That might not matter when your child is 3, and it might matter a whole lot when your child is 8. So we need to look at what the custody looks like with your life, with your work schedule, with your obligations, with their schedule, their obligations, and with your spouse's schedule and their obligations as well, so we can make sure that you maintain that relationship that's so important with your child. Before I had kids, everybody always used to say parenting is hard. Parenting as a divorced or separated couple is even harder. We can get protections in place that help address temporary scheduling issues, that help address who have legal and physical custody, that help address the things that we can foresee and prevent that parental alienation that you may be concerned about right now. Give us a call and we're happy to help.